Hello guys, based upon the request that I received from few of you, I decided that I would structure the AI generated videos into a slightly different module wherein I first introduce the concept, then allow the AI to recap, and finally give a basic hint of what varieties of questions can be expected from exam perspective. Let's see how this goes. If the format suits everyone, we will continue with this module. In today's session, we are actually planning to have a look at the relationship that exists between a banker and a customer. So we have seen it in great detail in our classroom. I'm just trying to recap what we studied in the class. The basic relationship that exists between a banker and his customer is that of getting money from the customer or lending money to the customer. So if the customer is depositing money into his account, he becomes the creditor and the banker becomes the debtor. If the customer is receiving some loan, then in that circumstance only the banker becomes the creditor and the customer becomes the person who has received the loan becomes the debtor. So depending upon what hat the banker is wearing at that particular point in time, we get to know whether he is a debtor or a creditor. The context really matters here. The functions of a banker primarily is with respect to that of deposits and lending. Apart from that, he can also indulge in ancillary functions and much more importantly, the secondary functions that we more aware of. So the secondary functions include collection of checks or execution of standing orders such as an ECS mandate, or it could be even take money from my account and deposit into my RD account every month. These are all some things that generally happen. Then stock exchange transactions through ECS mandates are also possible. Insurance activities are also being taken up by them. Apart from that, there are also other ancillary functions which are being made use of by specific customers, such as letters of credit or a traveler's check, or even keeping our jewels in a safe deposit locker. These are all ancillary functions. The primary function is deposit and lending. So depending upon the role that the banker is playing, he's wearing different hats. So he could be a bailer bailey. It could be a situation of a bailer bailey if it is a case of renting a bank locker. It could be a case of trustee beneficiary or even an agent and principal, as we had seen when we were discussing about Negotiable Instruments Act and collection of checks. There are also some special obligations that is binding a banker. First and foremost is honoring the checks of the customer. Then there is a mandate of silence. He has to maintain secrecy with respect to that of his customer's account unless otherwise there is expressed or implied consent or a compulsion because of law. We had discussed this with help of various case laws in our class. These are the landmark cases that should be compulsorily there in your paper when you are answering it. Then a banker is also having a bundle of legal rights, and it includes rights such as right of lien, right of set off, and right of appropriation, each of which could turn up as a specific small question along with case laws. Now let's take the help of AI to recap our session, and I will wind up by listing out some of the questions that could be asked from.
Welcome to our legal masterclass. Today, we're going to pull back the curtain on a relationship most of us have, but almost never think about the one with your bank. You know, the second you open an account, you're stepping into a really complex legal agreement. So, we're going to break down exactly what that means. Okay, let's just jump right in with a question that gets to the heart of it all. When you put your hard-earned money into a bank account, legally speaking, what are you? What's your official title in that relationship? Give it a thought, because the answer is probably not what you think. But hang on, before I give you the answer, we gotta start where every legal discussion has to start, with the definitions. As you can see right here from these notes, the Banking Regulation Act is super clear. Banking means accepting deposits from you, the public, for the purpose of lending that money out or investing it. This one simple idea, it's the foundation for everything we're about to cover. So here's our game plan for today. We'll kick things off with that surprising relationship I mentioned. Then, we'll look at all the different hats of bankwares. We'll get into its most important promise to you, what happens when that promise gets broken, and finally, what rights the bank has in all this. All right, Section 1, the surprising relationship. And I call it that because, honestly, the legal reality of what happens when you deposit money is pretty much the opposite of how it feels. And here it is, the big reveal. Legally, when you deposit money, you're not just storing it, you are lending it to the bank. That makes you the creditor, and it makes the bank your debtor. Yep, the bank owes you money. That's a huge mental shift, right? And it changes everything. And look, this isn't just some dusty legal theory. It is the absolute core of the contract you sign. These original notes show it right here, plain as day. The very moment the bank takes your deposit, a legal debt is created, and they are on the hook to pay you back. But here's the crucial detail. Even though the bank is your debtor, they don't have to just give the money back whenever they feel like it. Think of it like a giant IOU that you get to cash in whenever you want. It's your demand. Swiping your card, writing a check, hitting the ATM, that's the trigger for their legal duty to pay up. So now that we've nailed down that primary relationship, debtor and creditor, things start to get even more interesting. Because see, that's just the main role. Depending on what you're doing, your bank actually wears a whole bunch of different hats. For example, the bank can be what's called a bailee. It's a fancy legal term, but it just means they're safeguarding your property. So when you use a safe deposit box, the bank isn't your debtor for what's inside. They're more like a really, really secure storage unit. Or they can act as your agent, like when they collect a check for you. Or they can be a mortgagee when they give you a home loan. So this brings us to a perfect little pop quiz to see if you're following. If you rent a safe deposit box and stick your family jewels in there, is the bank your debtor for those jewels? And the answer is nope. In that specific case, the hat changes. The relationship shifts from debtor-creditor to what's called bailee-bailer. Okay, let's move on to one of the most important duties the bank has to you. I like to call it the promise of secrecy. This is a massive obligation, and it's really what all the trust in banking is built on. And this duty is incredibly broad and powerful. The bank has to keep a lid on all the information about your accounts, your balance, your loans, what you buy, all of it. It's basically like doctor-patient confidentiality, but for your wallet. And as you can see from the source notes right here, this duty of secrecy is a big deal. It's listed right up there with the bank's other main job, honoring your checks. So this isn't some minor thing, it's a fundamental part of the deal. But, like in any good legal drama, there are exceptions. This promise isn't ironclad. So our next section dives into a really important question. When is it okay for this sacred promise of secrecy to be broken? So let's just ask it directly. Is this duty of secrecy absolute? Is there anything or anyone that can make a bank spill the beans on your financial life? And the answer is yes, but only in a few very specific situations. First, if you give them your permission, of course. Second, if they are compelled by law, think a court order. Third, if there's a higher public duty, like preventing crime. And fourth, if the bank has to protect its own interests, like if they have to sue you to get back a loan. And this stuff has real teeth. There was a famous case way back in 1924 called the Tournier case. A bank told a customer's boss about their debts, the customer got fired, and the court decided the bank totally breached its duty. So yeah, this promise matters. Okay, we've talked a lot about the bank's duties to you. But what about the other side of the coin? Let's flip the script and look at the bank's own rights, the things that balance out all those obligations. So the bank has a few key rights. The right of lien lets them hold onto your property as security for a debt. The right of set-off is a really big one. It lets the bank move money between your accounts to cover something you owe them. So if you default on a loan, they can legally take that money from your savings account to pay for it. And of course, they have the right to charge you interest and other fees. And looking at our source notes one more time, we can see where these rights come from. They're not just made up. They are the legal tools that allow a bank to actually work as a business, to manage risk and stay afloat. So when you boil it all down, it's really about two parties in a very specific kind of partnership. And it really is a two-way street. The whole banker-customer relationship is this delicate, complex legal balancing act. On one side, you've got your rights as a creditor and your right to privacy. On the other side, you have the bank's rights as a business trying to manage risk. It's a partnership with duties on both sides.
A 12-mark question combining the duties, obligations, as well as the rights of the bankers can be asked. Apart from that, 7-mark question focusing specifically upon the primary functions, secondary functions, or ancillary functions can be asked, such as specifically focusing upon aspects of how to open a locker account, what are the conditions attached to it. Questions can also be based upon areas like when does a banker become a bailer, or when is there a relationship between the banker and the customer, as that of a mortgagor, mortgagee. Could also be about jewel loans. These are all subsidiary legal rules that can turn up as 7-mark questions. Then, with respect to that of 5 marks as well as problem-based questions, specifically the rights can be focused upon. Problem wherein mathematical calculations relating to right of lien, right of set-off, or right of appropriation can be asked. In a 7-mark question, Clayton's rule or right of appropriation can again be questioned, or it could turn up as a 9-mark problem-based question. It's a very important area that you have studied when you studied contracts also. Finally, implied consent and juxtaposing it with that of duty of secrecy and garnishee order or IT orders. These are the areas in which questions can be asked as problem-based questions. If you have any doubts regarding this, please raise it in the GCR or in the YouTube or even in our WhatsApp group. That's it, guys. Thank you.